Because of those workers who came forward, and I just want to say a word to them directly, because you noticed that something didn't add up, and you calmly but diligently did something about it, you've won back the retirements and payments and so much more for so many people across this Commonwealth. I want to thank those who spoke up. Your voices truly made a difference. Earlier today, in a Center County courtroom, the Glen O. Hawbaker Company pled to 4 counts of theft for their illegal prevailing wage schemes, which stole tens of millions of dollars from Pennsylvania workers. Between 2003 and 2018, Hawbaker was awarded $1.7 billion in PennDOT contracts alone. They are one of the largest construction companies in the region, and for violating the Pennsylvania Prevailing Wage Act and the federal Davis-Bacon Act, they will now pay the largest prevailing wage criminal restitution award in the history of the United States of America. A month ago, I met with some of the men and women who had their wages and retirements stolen by Hawbaker. And I told them, and some of you were in this room and heard me say it publicly, that we would do everything in our power to get them back every cent that they were owed under the law. A few minutes ago, I had the opportunity to speak to some of these workers, and I told them that we, together, made good on that promise. As a result of the plea, the Hawbaker Company is going to pay for all of the wages and retirements that they stole within the statute of limitations. The company will pay over $20 million to 1,267 Pennsylvania workers. 20,696,453 dollars to be exact. That's the amount they stole starting in 2015, leading up to 2018 when we began our investigation. To the workers who were stolen from, the corporate monitor that we just approved will be working to make sure that you receive the money that you are specifically owed very shortly. If you run into any issues or have any questions, we've set up a special number for you to call, 814-746-3518. Under the terms of this plea, payments must be made to these individuals, these 1,267 individuals, within 120 days. The third-party corporate monitor, who will make sure that they make good on their payments to workers and will review their pension, health, and welfare and other plans to make sure that nothing like this ever happens again. The bottom line is these workers will be made whole. This case shows exactly why I launched the Fair Labor section on my first day in office back in 2017. Because this office was willing to prosecute one of the largest construction companies in the state, 1,216 people will have a better shot now at their retirement. Will get the paychecks that they earned under the law and will have their work and their livelihoods protected and respected instead of ignored. Michael Singler is one of those people. When he first started working for Hawbaker, he told us he thought he was joining a company that treated employees like family. This was really important to him when he started working there back in 2007. After some time at Hawbaker, he realized that something was wrong. The only family the company seemed to be looking out for were the Hawbakers and their executives. So many more Hawbaker employees didn't even know that they were impacted. Look, when we talk about big fights, this is what we mean, helping everyday Pennsylvanians take on the powerful and the well-connected when they've been screwed. The Hawbaker scheme was sophisticated, and it was centered around stealing wages and benefit money from prevailing wage workers. They carefully carried out this scheme. Let me tell you how it worked. Look, first, you need to understand the Prevailing Wage Act. The prevailing wage is a requirement outlined in the Davis-Bacon Act and in the Pennsylvania Prevailing Wage Act, which levels the playing field by ensuring that workers make a fair wage for their work. It's not set by the employer. Hawbaker did not set the prevailing wage, but rather it's set by state and federal agencies, and contractors must agree to pay the prevailing wage in order to do a state project. So let me explain what this means in very real terms. For an individual highway painter, for example, in Center County, the prevailing wage for that job was about $39. That doesn't mean that the worker is seeing $39 an hour in their paycheck. They may be earning about $22 an hour in wages. So the question is, what about the rest of the money? What about the other $17? The remaining $17 for this highway painter, well, the law requires that the individual worker receive health care, retirement, and so-called fringe benefits that have to add up to that $39, the set prevailing wage for their job. And that's where Hawbaker stole from their employees in two different ways. They reported making health care and retirement payments that men like Michael Singler and Tim Lewis and Harry Ward never actually got. First, they told state and federal agencies that they put half of that fringe amount into the retirement accounts of prevailing wage workers. But in reality, here's what they did. They were spreading the money around all of their employees at Hawbaker, regardless of the type of work that they did. So the men and women doing the backbreaking work on Pennsylvania roadways had their retirement stolen from them by the C-suite executives who were sitting in their cozy offices on those hot summer days. They underfunded employee retirement accounts to the tune of about $15 million between 2015 and 2018. That left employees nearing retirement with less than they had legally earned in those prevailing wage contributions, a theft that grew each and every year as they missed out on the growth of their retirement accounts. Let me tell you about Tim Lewis. Tim Lewis went to his accountant to work on planning for retirement. He gave her, the accountant, his 401k statements, and she couldn't believe her eyes. She told Tim that the money in his account couldn't possibly be all the money he had earned during his time working at Hawbaker. That is what Tim learned from his accountant. Second, Hawbaker came along and overstated the cost of their health benefits by millions of dollars to pretend that these same workers received thousands of dollars in health care that they never did. How'd they do that? Well, think about the bill that comes to you from the hospital for, say, that $20,000 emergency room visit. If you have health insurance, what's actually billed to the insurance company by the hospital is far less than that $20,000 figure. And your out-of-pocket expenses, say $2,000 from that ER visit. Except what Hawbaker did was that they claimed they paid the entire $20,000 on behalf of their employees, which made it look like they were paying far more for health care than they actually were. Overstating the cost of their health care plan then allowed Hawbaker to report that they met the prevailing wage when in fact they really didn't. So back in 2018, when we began this investigation, the company claimed that it cost them $18.65 per hour to cover the health and welfare benefits of their employees. In reality, it only cost them $6.67. That's about a $12 difference that Hawbaker was able to pocket. That allowed them to steal from people like Aggie Hubler, a laborer for Hawbaker. Over the years, she worked so hard for decades, building highways, building roads, that she has permanent injuries on her thumbs and the bones of her hands to prove. You heard her speak about that before. She needs support in ensuring that her healthcare needs are met and helping her secure her retirement. Instead, the Hawbaker company stole from this woman who literally broke her hands on behalf of the work she was doing for the Hawbaker company. Protecting paychecks is a priority for me as your Attorney General. That's why I started the Fair Labor section under the leadership of Chief Deputy Attorney General Nancy Walker. This is the third in a series of wage theft and worker misclassification prosecutions. And I'm here to tell you today that it will not be the last. Because when one of the largest construction companies in the state is stealing from workers, you know it's a big problem. Look, these are tough and complex cases. This case alone took us 3 years to be able to recover that $20 million for those workers. But if we don't do them, if we turn a blind eye to this type of conduct, then we're allowing the workers that you heard from today and thousands more like them across this Commonwealth to get cheated and to allow these companies to steal from them. And we simply won't do that. Here's the bottom line. These workers, they're going to get their money back. This company is being held accountable. And every other company in Pennsylvania is now on notice that we are watching. And if they choose to conduct themselves the way Hawbaker has, or the Good Company has, or others have, we will hold them accountable. And we will do our part so companies across the Commonwealth can fairly and equitably and honestly compete for public work projects. That's good and fair for those companies, and it's good and fair for the taxpayers of the Commonwealth of Pennsylvania. This enforcement is helping Pennsylvania workers earn their rightful and a full paycheck, helping taxpayers and local communities get their fair share of revenue for roads and bridges and parks and trails and local police. It's also protecting law-abiding businesses that are at a competitive disadvantage when contractors get away with illegal schemes to steal from workers. Look, I've heard directly from contractors across Pennsylvania that follow the law, that follow the rules, and they believe that this enforcement helps their honest businesses. And by exposing these flagrant examples of wage theft and misclassification, we will deter employers from engaging in the same illegal schemes going forward. That's why my office and our partners in law enforcement are committed, deeply committed, to doing this work. It's why I've spoken directly to Vice President Harris and United States Labor Secretary Marty Walsh and Governor Wolf about the need for greater enforcement at the federal and state level. And it's why I'll end today with a call directly to Pennsylvanians. If you step up and know my office is here to help, we will be your advocates. The easiest way to report wage theft or worker misclassification is by emailing us at wagetheft@attorneygeneral.gov. And when we find another business employing these type of tactics, these types of schemes, we will fight for every Pennsylvania worker to get their rightful paycheck, their full paycheck. Too many Pennsylvanians go paycheck to paycheck, have loans and debt weighing them down, keeping them in second jobs. That's why I know we must enforce the laws designed to protect Pennsylvania workers. And as your Attorney General, I will continue to do so. Everyone who works hard deserves to retire with dignity, to enjoy time with family and friends, and to live their own American dream. Here in the Office of Attorney General, we'll continue to protect those American dreams here in Pennsylvania. We'll create a level playing field for every worker, and we will always have your back. And with that, I again just want to thank my team for their outstanding work on this complex case. Know that you did very good. There's a lot of people out there who are benefiting from your public service, and I'm profoundly grateful to each and every one of you. And with that, I'll do my best to try and answer some of your questions. Dennis.
Josh, are there any sanctions on criminal charges on any individuals and any sanctions on the company? Are they still allowed to get state contracts, for instance?
Sure. The criminal component of this case played out with the plea that was entered into today. The $20 million and all the other things I outlined are as part of that. The second part of your question, which is a good one, is not within the jurisdiction of this office. That'd be within the jurisdiction of the Wolf administration through Department of Labor and elsewhere as to whether they can contract with the state or some other municipality. By law, we don't have the authority to deal with those contracting issues.
Do you make any recommendations in that regard? Or?
I think the investigation, the charges we brought, the plea, speaks for itself, and it'll be up to the administration and local governments to determine whether this is really a company they want to do business with going forward.
Would it frustrate you if they continue to get contracts from the state?
I think I'm going to leave that up to the procurement agencies to make their judgment. I think there's a lot of good, honest companies out there who do the right thing, and if they have the best prices and the best skills, I would think those would be the companies that should be doing the work. Mark?
Good afternoon. So if I understand it correctly, the 20 million and the 1,200 victims, those are the ones that fit under the statute of limitations.
That's correct.
Did you make any examination of how many victims and how much of a loss there was before that? In other words, how much did they get away with, so to speak?
We know that this scheme was going on prior to the time period that we're allowed by law to investigate and hold companies accountable. Unfortunately, the statute of limitations didn't run long enough. That's a question, I think, more for the legislature and the governor as to whether or not they think the law should change and the statute of limitations should be longer. But obviously, we were bound by the statute of limitations, and that's why we focused our work on the period between 2015 and 2018.
Direct question, kind of following up with Mark,
Sure.
Attorney General. So these people are just sort of up the river? I mean, those that sort of fell outside of the statute of limitations, is there any discussion in your office or with other agencies to set up some kind of recovery fund for these folks?
Well, that would be a question for the legislature. We have the authority within the statute of limitations, and within that, we were able to get each and every one of the workers we identified, 1,267 workers, we were able to get them all of their money back. That's the $20 million plus figure.
Can I ask too, this might be a little bit early on, but is there an average settlement amount that folks are looking at this point, or will that be determined later on?
Sure. Each worker will not be receiving an average amount. They will be receiving what was stolen from them. And that's what the individual who's now been empowered over the next 120 days will set out to do. He will make payments typically in one chunk. It may come in two chunks, and they'll be done in a way that is advantageous to the individual based on tax rules and things like that. We want this corporate monitor to work closely with those workers and make sure that they get all of the money that's owed to them as quickly as possible.
Thanks.
Mark?
What about criminal liability for individuals? Companies can't go to jail, obviously. Was that ever considered, or is that still in the works? Or if it was ruled out, why?
We brought the case that we thought best represented the conduct that occurred. And we brought a case where we could have real accountability, where we could make these workers whole again, and where we could send a very clear message to every other company that we are watching. It's the largest Davis-Bacon prevailing wage theft case in the history of the United States. This sends a clear message that not only are we watching, but we have the capacity to handle these difficult cases. And we've put all the businesses on notice that they cannot get away with this type of conduct. Anything else? Molly, I know some people are on the live stream. Are there any questions there? Okay. Dennis.
Is there perhaps a loophole? Loophole's my word, maybe not the right word, but if this is a bad actor company, that the state would continue doing business with it, that the right hand's not talking to the left hand, and I know you're not the Wolf administration, you're not governor, at least at the moment. What do you make of that? Does there need to be a change where, if you're pointing out that there's a problem, somebody on the other side of the Capitol complex needs to recognize that?
Yeah, and I hope that they're paying attention. I hope that the administrators who procure services in the counties, in the cities, and certainly at the state level are paying attention to what type of actor this company is. It'll be up to them to make that determination. Look, I have the authority that the legislature and the governor give me under the Commonwealth Attorneys Act. The procurement power is something that rests with others. We have certainly made ourselves available to the powers that be that are on the procurement side to answer whatever questions they have. Obviously, we've done this in a very public way, so the public and those people charged with making procurement decisions are aware of what occurred here. And so they now need to go and make those decisions. And they should be held accountable for those decisions going forward.
My last question, what can you tell us about, obviously, there's a great thought that you're going to be running for governor. What can you tell us about that?
Dennis, I'm not going to engage in any type of political speculation, certainly not here in this room. I'm working my tail off for the good people of Pennsylvania as their Attorney General, and I think this case demonstrates that. Okay? Thank you all very, very much. Appreciate it.
Thank you.